It's Dina Doll and Lisa Graves. Lisa Graves is sitting in for Michael Popak on this episode of Unprecedented. As you know, Michael Popak celebrated a birthday this week, so he is traveling. Happy birthday to Popak. And so great to have you here, Lisa, to help me break down the Supreme Court latest news here. And as we say, we always have a lot to say every week because they make a lot of news. This week, the big headline, of course, was their ruling regarding the Texas gerrymandered maps, the new gerrymandered maps. We'll get into that. And I know probably most people know the summary, but we'll kind of get into a little bit more how the Supreme Court got there and what's next for voting rights. And then there's two very big cases coming next week to the Supreme Court. I am sure Popak and Legal AF are going to be live streaming the audio for that. So be sure to check that out. But we're going to tell you what these cases are about. So if you decide to listen in, or if you hear the recaps some other way at some point, you'll know. You'll understand it. You'll understand what to look for, and you'll understand perhaps the outcome of it, even just by listening. One of them has to do on, it's Monday. The first one is Monday. It's the big Humphreys executor case. Presidential power. How far will this Supreme Court go to expanding presidential power, go to their executive unitary theory? The current limits on when a president can fire heads of agencies or members of boards and commissions of agencies will be decided this term by the Supreme Court, and the oral argument for that is Monday. And then on Tuesday, we have a really big campaign finance case. This has not been talked about much, Lisa. It has not been in the news much, which kind of surprises me because campaign finance, a lot of voters really care about this issue, feel like we have too much money in politics. The case on Tuesday has to do with whether or not the Supreme Court is going to allow in even more money into our politics in a very important case. So those two important cases coming up. Let's start with Texas, though. Like I said, everyone knows the headline. Basically, the Supreme Court is allowing the newly gerrymandered cases, despite the fact that a Trump-appointed trial judge found the gerrymandering to be race-based and not politically based, at least more motivated, I guess you can say, by race. And that was unconstitutional. It was against the 14th and 15th Amendments, and overturned it. And we had this period of time thinking we don't know what these maps are going to look like. Of course, the Supreme Court and that appellate court upheld the trial court. The Supreme Court stepped in and said, oh no, we don't mind that. Or, that was not their legal summary, but basically they are allowing the Abbott newly gerrymandered case to go forward. And they did this in time for the December 8th filing deadline. So they got in just before, because the candidates had to file for their races by December 8th. And so they will be filing it based on these new maps. So Lisa, let's get your take on it, and then we can get into it. As we know, we actually saw real opinions on this. It wasn't just the shadow docket approved, without any reasoning. We did see both why they decided this way and a dissent.
Well, we did see a little more explanation than we usually see from these emergency orders, these shadow docket orders, but it was pretty slender given the fact that the lower court, the 3-judge panel that ruled on the Texas gerrymandered maps and found them with a detailed set of findings to be in violation of both the Voting Rights Act and the United States Constitution. We saw this court say that they're going to allow those maps to go forward, and that and asserting that it was necessary for them to go forward because the primary deadline was so quickly. In essence, that is sort of like process over substance. So it is the case that is a statutory deadline for filing for primaries on December 8th. But if a map violates the Constitution and the Voting Rights Act, then perhaps the date could yield. So the case could go forward, or the court could leave the lower court's ruling in place to say those maps are in violation. There need to be new maps. And then the time period for filing for the primaries could be changed. That's not some sort of magic thing necessarily, that the deadline is December 8th. It just is on statute that deadline. But if the maps violate our rights, then why should the date trump our rights? And so in this instance, you had the three, the Democratic appointees to the court dissenting from this ruling, another intervention by the Roberts Court to put its thumb or its fist on the scale, basically in favor of the Republican Party that orchestrated this supermajority on the court. And the easiest thing for this court to have done would have been to let the lower court ruling stand. But it didn't. It decided to jump in and allow those maps to go forward. And those maps, as you and our audience know, were designed to create 5 more strong chances for Republican seats, for Republican wins in the House, in order to protect Donald Trump's Republican power base in the House, regardless of what a majority of voters in fairly constructed districts would actually vote for. So I think of this as in my view, an illegitimate, hyper-partisan decision by a hyper-partisan court to disregard the factual findings below and the legal findings that were consistent with long-standing interpretations of Section 2 of the Voting Rights Act. And this comes as the court is considering a broader attack, in essence, assailing the Section 2 of the Voting Rights Act in the Louisiana case. So this is a real setback for voting, for representative government in America. Jasmine Crockett said in response, she's a representative from Texas, that the Republicans may think that they're gaining an edge through this kind of effort to rig the results. But she said, look out, because the voters are not going to take kindly to this effort to change the rules of the game in order to give a majority to a party that many people have extreme discontent over due to its subservience to an array of extreme and destructive policies of Donald Trump.
Yes. And I think she was one who lost her seat. And I think the most important, I thought, point of this was in the dissent when they really emphasized that the trial court judge did a 3-month hearing trial trying to get the facts of this, because it's very important. As we know, it is constitutional to redistrict based on politics. It may sound wrong. I fundamentally actually think that we should change it. Democrats tried to pass a federal law to change that, but that's not unconstitutional. So they had to, it was a fact-finding mission. Did the legislature do this for race, or did they do this for politics? And there were so many comments. There was a comment by Governor Abbott, who he was asked, at the press whether or not he was doing it for political reasons, and he said no, that they were doing it not for political reasons. Of course, he was, so they had so much evidence, and the dissent says, points to that, and that, she said that we may be a higher court, but we're not better at finding facts than the trial court. That is their mission, and the quotes. There was another part where it just talks about how they did it. It says, the district court's task then was a singular factual one. It had to choose between the plaintiff's race predominated count and the state's race never entered the picture story. To do so, it had a 9-day hearing during which it heard from 23 witnesses. Let me put the glasses on. Received into evidence thousands of exhibits and watched many hours of video footage of legislators and Governor Abbott discussing the proposed map as it was under consideration. So, during those 3 months, I guess it was a 9-month hearing there, or 9-day hearing there, she was saying. But the point was, is they looked into it, right? They decided based on the facts. And the majority, they really just said we need deference to a legislative body. The court should be giving legislative body deference. If they said this was because of politics and not race, we should kind of take their word for it. We don't really work like that in the rule of law, right? Like if you and I were in trial and even we had a dispute on a contract, I can't go in there and be like, well, you have to take my word for it, what my contract means, right? Yeah. That's essentially what the majority did. And I thought the dissent pointing out the fact that, this is a fact finding. We aren't mind readers. We don't know. We look into the evidence. And although we were not surprised that the Republican majority court ruled in favor of Texas, their reasoning was weak, let's say. But also, I think it's important to point out that the majority acted as if this is just a temporary ruling. You're going to have a chance to have a full appeal. And it is true. This could, if the parties continue to want to take this on, could continue to appeal this and theoretically can go back to the Supreme Court. It was just this like temporary stay. But in actuality, 3 years down the line, I mean, who even knows what politics are going to look like? You know, I mean, it essentially kills the case, but they tried to act as if it didn't. Like, don't worry, we'll take another look at this, right? And trying to separate reality from the law gets you into these little dangerous tactics. But that was another argument that they use. I'd also think it's interesting, Lisa, what you think about this, because I also think that they plan on probably just gutting this section of the Voting Rights Act based on the Louisiana October hearing. And that's probably why they ruled against the voters that took this case and in favor of Texas, is because fundamentally they no longer believe that there should be race-based protections in the Voting Rights Act. But rather than say, hey guys, we're going to get rid of this section anyway, so we're not going to give you a pass now. But I think that's where they're going. And that was really why they had such a weak argument for it, because their main argument is that they don't care anymore if districts get gerrymandered based on race. I think they're no longer going to protect that anyway. What do you think?
Yeah, I do think that it was a signal of where the court is headed in the Louisiana, in the Calais case. And I think that they don't care. They don't care about this impact. That's actually been a through line for John Roberts. He devoted the first part of his legal career to try to attack efforts to repair the damage done to the Voting Rights Act by a decision that Roberts's boss, his mentor Rehnquist, joined, that tried to say that you couldn't take into account the effects, the racial effects of changes in the rules under Section 2 of the Voting Rights Act. He lost that battle in the Reagan administration. And now here he comes in 2025, 2026 to try to win what he couldn't win back then. And that's a huge loss for the American people, because the fact is, as the lower court found, and as the dissent from this order pointed out, the lower court found that there were racially disparate impacts, that this does qualify as a violation of the Voting Rights Act and of the Constitution. And I really think the analogy that you used, the analogy you used is so compelling, Dina, because when you think about pretext under the law, the notion that, an employer may say, oh, we're firing you for efficiency, but it's actually really age or gender or race. At one point, the Supreme Court, an earlier Supreme Court, noted that the Constitution forbids both simple-minded and sophisticated discrimination. So what's happening is the legislatures have gotten more sophisticated in how they describe what they're doing in order to try to avoid saying overtly that they're racially motivated. But then you look at the effect and you can see, as the lower court found, how the way they redrew the maps dilutes the black vote, dilutes the brown vote in Texas, definitively does so, eliminates seats that are held by minority Americans from minority races in this country or ethnicity. And so what the court is doing is basically rewriting the law and ignoring the facts. And I, as with your experience, as a trial lawyer and legal field, I just think it's so important for people to understand, for me to emphasize something you said, which is the lower court is the fact-finding body. And in this instance, it didn't just take a brief and just, go in a binary way and rule for one side or the other. It actually conducted detailed hearings, many witnesses, many exhibits to make factual findings. And that's actually nothing the Supreme Court does. The Supreme Court does not do that. It doesn't hear from witnesses. It doesn't watch testimony or video testimony. It doesn't review thousands of pages of exhibits. It is not a fact-finding body. And indeed, under the law, the job of the U.S. Supreme Court is to defer to the findings of fact by the lower court, unless they're clearly erroneous, unless there's some really serious error in those factual findings. And there were no serious factual errors here. In essence, the court suggested that maybe there's a legal error, which I think was a bit of a tell toward how the court is leaning on basically decimating the Voting Rights Act of the Voting Rights Act of 1965, Section 2. The fact is that the court has not done so yet. It is still binding law as of this minute. And in fact, in the case that came out of Alabama just a year or two ago, the Milligan case, the court reaffirmed that Section 2 is still binding. And so the lower court, the 3-judge panel, did nothing wrong. The lower court was following the law and following the facts. But what we have, in my view, is an arrogant, out of control U.S. Supreme Court. The Roberts Court is drunk on the power it has with its supermajority. It feels free to disregard the work, the labor, the devotion to the rule of law and to the facts that the lower court judges are engaged in. And instead it itself, the Roberts Court, is engaged in a very partisan political activity to aid the party that created its supermajority, to the detriment of our law and to the disregard of the facts. And that's
Absolutely.
that's what Roberts did in the Voting Rights Act decision in Shelby in 2013. Congress made detailed factual findings about why, in that case, Section 4 and Section 5 of the Voting Rights Act, the pre-clearance provisions were necessary to be extended through at least 2030. They found that there was an ongoing threat to voting rights and efforts to make it harder to secure representation for minorities, which we've seen in the years since then. And Roberts, like with the wave of a pen, but like an axe, just disregarded those factual findings and asserted, it's been enough time. We're just going to move on and pretend like we don't need these provisions because, in his view, in essence, it's been too long. But that doesn't mean that the problems have been fixed. That doesn't mean that we don't have this effort by white legislatures to loot black voting. In fact, we do. And it's even on the rise, I would say, nowadays.
Absolutely. I mean, Justice Ginsburg gave that famous quote in her dissent to that, saying, just because an umbrella is working in the rain, you don't stop using the umbrella. They are definitely they are activist judges, and they are changing the law too quickly and too often. The Supreme Court is supposed to be a steady ship and maybe changes on the margins, and they are not. But one thing for those who care about California's fight, because the DOJ is suing California, saying, ironically, that map that was passed by the voters is a violation of the Voting Rights Act, right? Like, they care about it in one instance and don't in another. And the 3 judges, Gorsuch, Kavanaugh, and Alito, made a point in the opinion to say that it was very clear the California maps were drawn in a political way. So that is as much of a telegraph. DOJ, you might as well drop this lawsuit because you're not going to win. So those of us who care about the practical outcomes, that at least, I mean, it was true. There was no good evidence that the California one had anything to do with race. I mean, from the beginning, Newsom talked about it being a counter to the political power grab. And those judges did at least kind of help California in that respect. So let's move on to the other disturbing things about this Roberts Court. So on Monday, we have the Slaughter case. As we know, those of us who have been watching Unprecedented, following this along with us, this executive unitary theory of really trying to give the president more expansive power is coming to a head. There's a Humphreys executor 1935 case. And the question presented to the court includes specifically whether or not this case should be overturned. So they may very well overturn it based on the Monday's oral argument. Their question presented, in addition to whether or not it should be overturned, is whether the statutory removal protections for members of the Federal Trade Commission violate the separation of powers, and also whether a federal court may prevent a person's removal from public office either through equitable relief or under the law. So 2 really kind of concerning things in those questions presented. One is the separation of powers, basically. the case in 1935 had ruled that because Congress had written it that the commissioner could not, and it was the FTC commissioner, could not be removed but for cause, right? And then the president tried to remove him, and the Supreme Court said, no, you can't. This is a quasi-legislative, quasi-judicial commission. It's not a solely executive commission, so you don't have sole power over it. You basically have to like share the power. They allowed you at some times for cause to remove it, but that's it. This was we're trying to balance the powers. That has been the law. Again, 2020 was kind of the first chip. Roberts likes to chip away at things normally. Yep. He likes to not do things all at once. He likes to chip. That was the first chip. Trump had tried to remove somebody from the federal commission, the commission, the Consumer Financial Protections Bureau, and Roberts let him, saying, oh, because this is just the one person, but if it was a member of a multi-commission, then you can't. Well, that distinction really didn't make any sense anyway. And now, of course, you have a situation where this is a multi-member commission, and look at, they're considering removing it, right? So Roberts likes to chip things away because then, as you always point out, he can appear to be the statesman, right? We have this end result. We just spread it out over a lot of years. So that's Monday's argument about slaughter. I mean, you can kind of tell what my opinion is of probably where this is going to go. I actually was almost even more concerned with whether or not a federal court may prevent a person's removal, because who else is going to prevent it? So if they are saying, let's even say if they give this, they're most likely going to give the president more expansive power, remove it. But who else but the court would stop something like that? So that they're removing their own check of power. So what is your take? What should people look for, do you think, in Monday's argument?
Well, I really appreciate your description of it, Dina. This case is exactly the same agency that the precedent relates to, which is the FTC. And as you point out, it's a commission that has legislative components. It's not purely an executive branch, even though I didn't consider the Consumer Financial Protection Board or Bureau, in essence, to be as narrow as Roberts treated it in the SELA law decision. But I just wrote a piece. That just went out on Substack about what John Roberts did in that immunity decision, Trump versus United States, where he goes out of his way to say that a president's power to fire anyone in the executive branch is limitless. Cannot be constrained. Now, that's not actually been the law in the United States. This unitary executive theory has been a fringe theory. It has not been embraced by the court. It's contrary to Humphrey's executor in particular for the FTC and agencies that are constituted like it, where Congress said, we're not going to let a president just overtake an agency that has this role. We're going to try to make sure that the person can only be fired for cause. But Trump doesn't want to fire people for cause. He doesn't want to be bothered with that. He wants to unilaterally cut down agencies and install loyalists, as well as ordinary employees at all levels of government who are supposed to be civil servants and not loyalists, party loyalists to him. And so when you look at that Trump versus United States case, what I saw and what I wrote about was how Roberts went out of his way to suggest that the pardon power is completely unlimited. And in that same section, he asserts that the president's power to fire executive branch, people that are working for the executive branch, in essence, including commissions, and he cites SELA law in that case, that the president has unlimited power to do so. What that means, I think, goes back to your question about that second question, which is suggesting that courts would have no role in responding to unilateral firings by a president on an arbitrary basis, or to install his loyalists regardless of what Congress has done to try to protect certain types of agencies, to have a rhythm or a system for bipartisan appointments to agencies so that there's fair representation, have a system of civil service and civil servants who, under the Hatch Act, cannot be fired for political reasons, or contracts that the government enters into with federal employees. What Roberts is suggesting and suggested in that immunity case, which didn't get really covered because the immunity case was the biggest deal in terms of this counter-constitutional agenda by John Roberts to exonerate Trump and pave the way for his return to power, but hidden in essence, or like less emphasized, but significantly in that case, he suggested that the president is unbound in his ability to fire employees of the executive branch or that are within the executive branch structure in some way. And that's extraordinary. That has not been the law in the United States. That has not been the practice. And that is an extreme version of this already extreme theory, this unitary executive theory that tries to make a president of the United States into a king, giving him king-like powers in the same way, along the same vein that John Roberts orchestrated that unprecedented destructive ruling, setting Donald Trump above the law when it comes to criminal law through that immunity decision, that destructive, just, I think, incredibly outlandish, outrageous decision that we saw last year. So this is part and parcel of that. I think that what we're going to hear on Monday is the Republican appointees trying to justify this move to embrace fully this unitary executive theory and to dramatically remake the 21st century by giving Trump even more king-like powers.
Absolutely. And it shocks me that they're willing to do with somebody like him. You know, I could see them in theory. Oh, this is my theory, but he's the example for why you don't want somebody to have so much power. And they seem to me still willing to do it. Anyway, I know Justice Amy Coney Barrett earlier, like a few months ago in her book tour was like, oh, we don't look at the president, we look at the presidency. Well, in this situation, you should look at the president because, you know, he's Nixon times 10 and look at all the laws they had to do to rein him in. And the thing is, the answer to a too powerful Supreme Court and a too powerful president is a more powerful Congress. And our Congress has been kind of dysfunctional for a really long time. We either need to elect better people or get rid of the filibuster, or, you know, they could change the laws to make it. Maybe those cabinets become less executive because of that. I mean, there is a branch that's too quiet right now that needs to wake up, basically. So the last case was on Tuesday. So back to back here, you'll have your day filled with wherever you're driving or working in the background, listening to your cases. This one has to do with campaign finance. And this move, basically the Republican Party is right now, the parties, both the Democrat and Republican Party, can coordinate a certain amount of campaign expenditures with the candidate, right? So they can spend, depending on the office, 100,000 or even like in the millions, I think with the Senate campaign, with that candidate themselves. Coordinate on messaging. Hey, do we need more social media? Do we need more ads? Like, what does our message want to be? How do we do this? They can coordinate, but there's a cap. So the Republican Party is sued the FEC saying we shouldn't have a cap. We have a First Amendment right. We heard this before, right? Citizens United argument basically all over again. You are restricting our First Amendment by putting this cap on coordination. If the Supreme Court rules in favor of the party, it means that the parties are going to become hugely powerful because unlike PACs, because PACs also cannot coordinate their money with the candidate, these parties will have unlimited money to coordinate with the candidates. And really, you'll have probably wealthy donors, right? Like Elon Musk will start donating to the RNC, right? Or to certain senatorial committees, et cetera. And they will be able to buy elections in a much bigger way. And so I really wanted us to talk about this because I'm not hearing enough talk about this somehow. I know there's like so much going on in the news lately, but this is a really important case. So many voters are so tired of money in politics. I mean, I personally think it's the most corrupting thing that we have in our elections is money in politics. And interestingly, of course, you're seeing candidates who don't take money, like Mamdani's big win because he didn't take outside money. I think voters are like hungry for people who are not bought and paid for, who don't speak like a typical politician. And so at the same time, though, you see these parties Republican Party, I'm sure if the Democrats were allowed to do it, they oppose this, even though it would benefit them because they do believe in keeping money outside of politics and believe wealthy donors will be able to control elections. But this will result in the Democratic Party and the Republican Party becoming uber powerful. So what's your take on this, Lisa? Is this a done deal because of Citizens United, or is there some hope?
Well, this is a very serious matter because there have been limits on coordination between candidates and outside groups. That's been eroded over the last several years, but there are still some limits in place. And this case is designed or intended to end those limits on coordination that have been longstanding limits, although they've been degraded by this court and by other related rulings. This whole system that we're in, this campaign finance system, which is really about preventing corruption. The original statute that the Federal Election Campaign Act replaced was the Federal Anti-Corruption Act, because it's designed to prevent undue influence by very powerful people within a representative democracy. And so initially, that Federal Election Campaign Act, the FECA, and its immediate amendments set up a system of campaign finance, of financing campaigns that was in the open. If you gave to a candidate, it was only within these certain limits. It had to be disclosed who you were, who you are, and how that money was spent needed to be disclosed. And you couldn't give it an unlimited amount, even if it was yourself. Mm-hmm. Early on in the Buckley case, the Supreme Court allowed self-financing of campaigns, political campaigns outside of those limits. That's how David Koch, Charles Koch, the billionaire's brother, ran for vice president back in 1980. Fast forward to the late 90s. It was the Kochs, Charles Koch, who floated a trial balloon to try to get around those hard limits and push dark money forward. It was Charles Koch who did so through a thing called Triad. And that and other things that were happening resulted in Congress passing the Bipartisan Campaign Reform Act, BICRA, which was known as McCain-Feingold. That bipartisan law was designed to say, look, you cannot have this dark money that obviously is designed to influence elections coming in without disclosure. Who's spending this money? Who's really behind this effort? And in 2010, the Supreme Court issued that Citizens United decision you mentioned, Dina. That decision was a 5-4 decision in which it overturned those limits and suggested that because there isn't coordination, there would be little impact from these outside groups. They wouldn't be very effective. That was completely false. Obviously, they're very effective. In fact, those outside groups tend to run the opposition campaigns, the dirty campaigns, the sort of smear campaigns, the attack ads. They're very powerful. And in fact, what we've seen since Citizens United is that more money is being spent by outside groups than by by what's disclosed through the candidates and the campaigns, the party. So it's very powerful. At the state level, we have seen state elected officials like Scott Walker raise money for an outside group that he could not raise for himself. $1 million checks that he could not receive as a candidate for governor that were sent to an outside group for Scott Walker's, campaign, in essence, to help Scott Walker. He could not have accepted those checks as governor, as someone running for office, but he was raising money for an outside group that supposedly was not going to be coordinating with the campaign. When that issue came up to the Supreme Court, the U.S. Supreme Court, the court declined to, consider that case. It rejected cert. Now we have a case that has been pursued by Vance, the National Republican Senatorial Committee, the NRSC. This case is designed to destroy limits on coordination. What that means is even more billionaire influence, even more outside money, now inside money, basically being directly coordinated with the campaign, not some sort of Chinese wall separating, some parts of these activities. And again, they're trying to claim that our First Amendment means that they can do anything with money and that we cannot constrain it. We cannot regulate it through our representatives. We cannot have reasonable rules to protect from this grotesque distortion of our democracy through billionaires like Elon Musk, who spent more himself than any other person has ever spent trying to win a presidency. And that's just the money that we know about, not what other money he may have spent. So the fact is the American people, sorry, I'm on a tirade here, but the American people overwhelmingly think there's too much money in politics, overwhelmingly think this area should be reformed. But this Supreme Court, so beholden to these same billionaire interests, so determined, in my view, to protect the party that installed it, that created the supermajority, they are willing now to consider striking down even those last few limits on coordination at the request, again, of the Republican Party, because it aids the Republican Party, because they have more billionaires at their disposal who don't want regulation, who don't want fair taxes, who want these massive gains for themselves, playing politics because of decisions like Citizens United, which, by the way, never should have been issued, because we know now that Clarence Thomas's wife accepted a $500,000 gift from Harlan Crow as that case was pending to fund a group to take advantage of the decision to come in Citizens United. He should have recused, should have been a 4-4 decision. The lower court's rulings on campaign finance reform should have been upheld, but instead we've had this march toward a dollarocracy, as Bob McChesney and John Nichols put it in their book, a dollarocracy as opposed to a democracy, and the American people reject that. So I'm worried about this case to come. I'm worried about the argument to come. But that's my view of the lay of the land.
No, absolutely, and Clarence Thomas should face impeachment for that.
Yes.
That is the solution to our Supreme Court problem is, I believe, impeachment for the actual issues that they have, violated the ethics. They're not recusing himself. Well, one answer to money in politics, because we probably can't count on the Supreme Court, but hopefully we gave you enough of a preview. So when you talk about it on Tuesday and you read about it, you'll understand the issues at hand, is we still get a chance to decide who we vote for. And more people are asking the questions of candidates who they take money from and whether or not they take money. And I do find it ironic that right at a time where, frankly, both Democrats and Republicans are not that happy with their parties and the leadership of their parties, these parties may be becoming more powerful. But the answer, not the candidate who gets the most money doesn't always win. And if we care as voters in keeping money out of politics, we can check to see where our candidates are getting money from. That's a really simple and easy way to combat this, because, I think for a long time, the Supreme Court ruled in favor of civil rights and really opened up so many doors, LGBTQ, gay marriage, a right to have an abortion. But for many years in this country, the Supreme Court did not help the people out, were an obstacle. And there are other ways of still being able to protect our right to vote, or other ways. Some of it is what we can do, our states can do, our cities can do, our Congress can do. And so kind of like, I think part of the reason why Trump has gotten so bad is because we have always deferred to the president too much. We say, we didn't want a king, but we did treat them like this untouchable person, which is why Merrick Garland I blame Merrick Garland more than the Supreme Court for that debacle of the criminal case. Of course, it was going to go up to the Supreme Court. No former president ever been indicted before. Of course, they were going to give him some presumption of immunity. He revised his indictment, Jack Smith. He could have still stood trial, but it was too close to the election, but that was Merrick Garland, thinking the president was untouchable. We can't, as American people, defer anymore. Right. And I think it's the same with the Supreme Court. We shouldn't defer and say Supreme Court is the law of the land. And once they say something, it's like the mountain on high and nothing can be done. It's not, a lot of times Congress can make a law that essentially overturns it, because if they're saying it's not in the Constitution, doesn't mean that Congress can't create a law protecting that right. We have to look, as the irony is this is a Supreme Court show, but I think it's important to understand how the Supreme Court works, and it is co-equal. And if we make it too high and we say, well, they rule this way, then all is lost. We give up and campaign, is corrupt forever in our elections. There's so much the federal government can still do, even with these bad things, and so much each of us as voters can do. So anyway, just to kind of end on that note, hopefully, because otherwise this was kind of bad news from the Supreme Court this week. As we enjoy our weekend, we need to have some optimism here. But Lisa, thank you so much for joining and stepping in. I love getting a chance to talk to you always. And I know Popak hopefully enjoyed his travels for his birthday, wishing him all the best in the new year. And if you haven't subscribed to Legal AF, that could be your birthday present to Michael Popak. He would surely love it. I think we're getting really close to 1 million. If you haven't checked out the Substack, Lisa and I both post articles all the time for the Substack. Really great stuff. He links filings and all that kind of stuff. And find us on social media everywhere. Lisa and I are kind of all over the place too. But anyway, thanks for joining me today. Look forward to talking to you again soon.
Thanks, Dina. It's a joy to be on your show and try to swap in or sub in for Popak. And again, happy birthday to him. And thank you everyone for tuning in. And it's going to be a big week at the court next week. Thanks, Dina, for inviting me on.
I'm Michael Popak, and I got some big news for our audience. Most of you know me as the co-founder of Midas Touches Legal AF and the Legal AF YouTube channel, or as a 35-year national trial lawyer. Now, building on what we started together on Legal AF, I've launched a new law firm, the Popak Firm, dedicated to obtaining justice through compassionate and zealous legal representation. At the Popak Firm, we are focused on obtaining justice for those who have been injured or damaged by a life-altering event, by securing the highest dollar recoveries. I've been tirelessly fighting for justice for the last 35 years, so my own law firm organically building on my Legal AF work just feels right. And I've handpicked a team of top-tier trial fighters and settlement experts throughout all 50 states known as big auto injury attorneys who have the know-how to beat heartless insurance companies, corporations, government entities, and their attorneys. Big Auto's attorneys working with my firm are rock stars in their respective states and collectively responsible for billions of dollars in recoveries. So if you or a loved one have been on the wrong side of a catastrophic auto, motor vehicle, rideshare, or truck accident, suffered a personal injury, or been the victim of medical malpractice, employment harassment or discrimination, or suffered a violation of your civil and constitutional rights, then contact the Popak Firm today at 1-877-POPAK-AF or by visiting my website at www.thepopakfirm.com and fill out a free case evaluation form. And if we determine that you have a case and you sign with us, we don't get paid unless you do. The Popak Firm, fighting for your justice every step of the way.